Welcome to the Utah Court of Appeals. We have one case on for this morning. It's Duffin versus Duffin. Counsel would state their appearances, please.
Julie Nelson for appellant James Duffin.
Jay Kinkins here on behalf of the appellee, Brandy Duffin.
All right, you're both veterans here, unless you have any questions. Do either of you have any questions? See none, you've reserved 5 minutes then.
Yes, thank you.
You may proceed.
I have a cold too. Oh, my thoughts are clearer than my nose, sorry. And last week I filed a suggestion of mootness, and I want to make sure that that was received.
It was.
Great, thank you. All right. Julie Nelson on behalf of appellant James Duffin. The heart of this case is that my client, Dad, would like to spend more time with his children. But the trial court somehow seems insistent on sending those children to daycare, 10 hours a day, even when Dad is available. This does not make sense from our perspective.
Is that the, it seemed that your focus shifted a little bit between the principal brief and the reply brief. Maybe I misread it, but it's pretty consistent with what you just said in your principal brief, that this is all about Dad having time with the children, but then there was an issue of him working full-time, and it seemed like in the reply brief that it was Dad or his mother, grandma, I guess that would be, or some other situation, kind of not so much focused on enhancing the relationship, although that may be important, but also about just costs, bottom line cost. Was there that shift between the brief?
It wasn't intended to be a shift in the sense that what you've just described is, I would say, a collection of all of our points, meaning that Dad wants more time with the kids. Dad also thinks that the relationship between his kids and his parents are very important. The record is replete with, we know that his relationship with his own grandparents had been very important. Dad has said that his job is flexible. He's working full time, but his job is flexible. He can provide that care. When he's not able to provide that care, his mother's available to provide that care, which is important in two ways. One, it builds important relationships that the code does talk about, and we'll get into that in a minute, about the code's emphasis on parental support over surrogate care. But also there's a cost component. The code also suggests that if there is free or cheaper childcare costs, that those should be respected. So it's both of those things together. It's not exclusively a money issue, although the money issue is a factor here. Why are we paying for daycare when Dad and Grandma are available, willing, wanting to spend the time with the kids? And the trial court has said absolutely nothing negative about Dad's time with the kids, Grandma's time with the kids, nothing like that. But why are we paying for that and not allowing that relationship to grow?
But you have to acknowledge that more time in the sense of day-to-day, more time during the day, there's no question, and maybe there is, and you can tell me, but that fosters more interaction between these two parents, right? Like if there has to be a daily conversation about where the kids are gonna go, which also, we need to talk about the status of the oldest child and his medical issues. Doesn't that bottom line affect, it's going to create more opportunity for communication between these two people who the district court clearly has said do not communicate well.
Well, I have two responses to that.
Okay.
One is that if Dad had 50-50, then no, it would not do that because we know 50% of the time that the kids are with Dad. And if Mom is sending the kids to daycare on her 50% of the time, that is her prerogative. And I mean, Dad would still prefer that not to be the case, but if he's got the kids 50% of the time, then there wouldn't have to be as much communication about that. My second response is that I think it's pretty clear, actually, from this record that the daycare is the primary source of contention. In fact, the trial court even found that although James had disagreed with other decisions that Mom had made based on her final decision-making, that and this is at paragraph 40, Jimmy complains that Brandy has abused her final say authority, but the only example he has provided is her decision to put the kids in daycare during her parent time. That's the source of the problem. And the trial court addressed the source of the problem in a way by saying, well, now you've got to respond within 24 hours. Like, the trial court implemented an order to try to solve some of those communication problems.
But explain this to me. So James wants more time with his kids. Great. Files a petition to modify to increase the time to 50-50. But what he's saying is, I don't like that they're going to daycare, so I want more time. But I haven't proven, under my petition, I haven't proven my entitlement to more time yet.
Well, okay, so let's pull that apart. So in the initial decree, the judge says, I can't do 50-50 because
You live far away.
you live too far away and your communications aren't great. So he moves. He moves 4 miles away. And he also tries to improve his communications. The trial court then says, okay, I see that communications have improved. In fact, everyone agrees communications have improved. They just haven't improved enough. And
To give you
also,
50-50.
to give you 50-50, right. And also, the kids are thriving. And then in paragraph 70 the court says, the parties should be a little more flexible and just try to do what's in the best interest of the kids instead of fighting with each other. If we come back in a few years and I find that the parties are working really well together and the kids are a little older, 50-50 is always great for kids. But I need to see the parties communicating better and being a little less pedantic in the way they interpret and use this decree. So why is that important? It's important because first off, we're still not clear what the target is. Like, is Jimmy supposed to, of course he's supposed to continue to work on improving parental communications, setting that aside as a goal. Will that make a difference to 50-50? Is that actually what he's trying to do? Because the judge has also said the main thing is that they're thriving. And I would note that the equal parent time statutes, they don't talk about communication. Of course, communication is important. I understand that. But the judge is saying, 50-50 is for parents who communicate well. No, it's not. 50-50 is for parents who meet the 3 criteria under the equal parent time statute, which talks about their involvement with their children, whether they can manage the time. Whether they can manage the time is this incredibly important part, but Brandy is not managing the time. The kids are at daycare. Jimmy's the one who can manage the time. So when we look at the when we look at the statute that's about parent time, 81.9.20641 and 81.9.305, Jimmy's meeting those criteria. So the courts objected this own thing about communication, even though they're getting better, and I'm gonna put in this requirement that they're gonna have 24, or you have to respond within 24 hours. And the judge doesn't say that the communication is hurting the kids. I mean, we can all understand in the abstract that bad communication between parents hurts the kids, but the decision is supposed to be about what is in the best interests of the kids. And the judge is saying, it appears to me that the best interest of the kids is that they go to daycare rather than be with their dad more often. We're not saying all of the time, more often.
So
We asked for.
the daycare issue seems to me to really turn on, paragraph 21 of the original decree, which says there shall be a right of first refusal only on overnights. You've got to get that changed in order to win this issue, don't you?
That was part of our petition to modify.
Because if that stays like it is, then
Not entirely, because if he has 50-50, then he never sends the kids to daycare on his days. But right now, he only has what used to be 35.1.
even if it stays 50-50, when Brandy has the kids, then according to this, she could then send the kids to daycare and that would be that, right?
That's correct. You're right. But first off, if Jimmy had 50-50, then it would reduce the number of days that they were at daycare.
Got it.
First. And second, otherwise, we moved to petition to modify the right of first refusal for the reasons that you have just stated.
Right, and that's what I'm saying, is in order to sort of gain ground on that, you've got to win those 2 issues, the 50-50 issue or you've got to switch that first refusal so that it's not just
Absolutely.
an overnight first refusal.
That's absolutely right.
Okay, and
Yes.
tell us why we should switch that. I mean, that seems a pretty discretionary thing.
I understand it seems pretty discretionary. I would point us to the advisory guidelines, which are now located in 81920213A, and they specifically talk about how parental care is better than surrogate care. Now, they're advisory guidelines, they're not mandatory, but it talks about how parental care is better than surrogate care. It talks about how cheaper daycare options are better. And that component would suggest to us that if there's a way that those kids don't need to go to daycare as often as they're going, then that's what's in their best interest. The code is leading us to say that's in their best interest. And I come back again to the trial court saying, the trial court never said anything about Jimmy not being a great dad. There are findings that Jimmy's a great dad. He's very involved with the kids. He's very involved in the therapy. He's very involved. And when the kids are with him, that's great. Knowing that the alternative is that the kids are at daycare, the trial court is still choosing either through 50-50 or through right of first refusal to send those kids to daycare rather than to send them to be with their dad.
Okay, one other question on this same point seems sort of tangentially related, and you have made this argument. You've argued that the trial court erred in not holding Brandy in contempt over this issue. And I guess I wonder how you get there, given that the decree that you're alleging Brandy violated contemptuously says first refusal only on overnights.
Okay, thank you. And I'm way into my rebuttal time, but that's okay.
Well, we're asking questions.
We have lots of questions.
Okay. The decree requires Brandy to ask Jimmy, to talk to Jimmy about legal custody issues. Brandy did not talk to him about the daycare. It's well known that she unilaterally hired a nanny and she unilaterally enrolled them in daycare. She didn't tell him that she was going to do that. She didn't ask his opinion. She was going to require him to pay half of it, of course, because he gets to pay half the work-related childcare. She didn't ask his opinion on this. She just did it. So that was what Jimmy filed the motion to enforce about, not on the right of first refusal. He filed the motion to enforce saying, you were supposed to discuss that with me. And the commissioner agreed that it was a legal custody decision that Brandy should have discussed with Jimmy, but the commissioner decided that she wasn't going to hold Brandy in contempt for it and she would certify that. So that issue gets certified to Judge Bates, who then decides, actually, it's not a legal custody issue at all. It's a day-to-day issue, and therefore I'm not going to hold Brandy in contempt for that. So it wasn't a right of first refusal contempt issue. It was, is this a legal custody issue?
Well, those two issues seem related to me.
Sure, but in terms of, I understood your question to be saying, how can you hold her in contempt for the right of first refusal? And we weren't doing that. We were just asking to hold her in contempt
so
for
she's
unilaterally deciding this.
I guess one element of contempt is, it has to be clear. You got to clearly understand what the order means, and then you have to knowingly violate it.
Right.
And so somebody looking at this decree that says right of first refusal only on overnights, but yeah, we need to talk about educational decisions. Parties shall discuss and try to reach agreement on questions of education. Somebody looking at this going, sending the kids to daycare during my own parent time doesn't seem to be something I need to talk about.
Fair enough.
And maybe that's ambiguous and maybe it isn't, but tell me how the order's clear enough that that would be contemptuous conduct to do
Well,
what
and
Brandy
my
did.
concern at this point is not, the contempt is less important to me than this decision now that sending them to daycare isn't a legal custody decision. My position, and I think we've articulated this in our briefs, is that it absolutely is a legal custody decision and it needs to be discussed between both of them. And the reason it matters is because if it's a day-to-day decision, then Brandy gets to do whatever she wants with it. But if it's a legal custody decision and Jimmy disagrees with the way that she uses her final decision-making, he can go to the special master or he can go to the judge and ask for a decision to override that or to make that change. But a day-to-day, he can't.
Well, again, I come back to this seems to be a question of what the trial judge decides to do about the scope of the right of first refusal. If the trial judge decides, well, it's in the best interest for these parties to have a right of first refusal during the day, then you're cooking with gas. But if the trial judge decides, hey, we don't, in this situation, we're only going to have a right of first refusal for overnights, then the question of whether it's a legal custody decision or a physical custody decision seems sort of, tangential.
So
If
I
the
just,
order says first refusal only on overnights, then it seems like that's something it's back to my original question, you've got to get that overturned here in order to win this issue, it seems to me.
well, the
Tell me
reason.
how I'm wrong.
Yeah, the reason I disagree with that is because I think the question of where the kids are going to school is a bigger question. So to use a well-known example, let's suppose that parents were divorced and one parent wanted to send them to public school and one parent was, let's say, Amish and didn't want them to go to public school. Then what? Well, we know that decision, that's a major decision that has constitutional implications, right? And so we would certainly say in that situation that we're talking at least about a legal custody decision, even if we're not having constitutional ramifications bleeding into it. So I would say, okay, we know that's a legal custody decision. What if the question is, are we gonna homeschool them or send them to school, to public school? Is that a legal custody decision? I think so, and so we move down from there. I haven't been thinking about who's taking care of them. So for example, in the right of first refusal, if the question was, well, should we have babysitter A or babysitter B, I would not be here arguing that that was a legal custody decision. But I would compare, are we sending them to daycare or are we sending them with dad? That's, to me, like homeschool versus public school.
Yeah,
Or-
that seems like a right of first refusal issue to me. Like, we've gotten down the decision tree to the point where if you're deciding daycare or dad, that's a right of first refusal. Does dad have the right to come in on my parent time and watch the kids? That's a right of first refusal issue. I help me understand how it's not.
Well, I'm not sure that I have another way of explaining it, except that I see it as being an educational decision. I mean, this is a fundamentally different structure for kids, whether they're being watched by daycare or whether they're being watched by parents. And we have the code telling us the advisory guidelines prefer parental care over surrogate care. The advisory guidelines it says that in multiple places, that we prefer parental care. So it's not just about in a way, it's about who's taking care of them during the day. But if we're talking about homeschool versus private school or, parochial school versus homeschool, something like that, even if it's the same hours of the day, that's a major parenting decision. Who is going to take care of our children? Who is going to guide their education? Who is going to guide their medical decisions? Those are all legal custody decisions, not just day-to-day. I mean, we can keep comparing to other types of major legal decisions. I mean, one of the things that I had said in my brief is that in the Kingston case, we know if you're gonna raise them in a religion, then that's a major parenting decision. But we know from Lobendon that who's gonna perform the baptism ceremony, that's not a major parenting decision. And I think this falls into that same kind of dichotomy. Fundamentally, daycare is different than parental care. Are we sending them to daycare or are we not sending them to daycare? And this is a difficult decision that people, when they're married to each other, have. These are difficult decisions that they wrestle with. What is going to be better for our children? So when the trial court just decides, well, Brandy gets to decide that unilaterally, I think that's more important that's not just about who's taking care of them during the day. That is what is our actual structure that we are using for education? What is our actual structure about who is going to provide this medical care? The same way about choosing different types of schools, different types of structures that we're imposing on our children. In my view, that's the same.
Aren't you asking us sort of to start sort of a slippery slope, though? Or are you asking us to define how far down the ladder one gets before it's not a major parenting decision?
This is an issue that comes up in so many families. Is this a legal decision? Surprisingly, we don't have very much case law telling us which decisions are major decisions and which decisions are minor decisions. Is it a slippery slope? Well, that's one way of looking at it. Another way of looking at it is we need more guidelines for people to know what is a major parenting decision so that we're not always having to argue by analogy. And because this issue may be the issue that comes up the most often, a decision on whether sending them to daycare is or is not a major parenting decision would be extraordinarily helpful. It would have made it clear for Brandy whether she was in contempt or not, whether she was supposed to discuss who took care of the children during the day with James. Now, even if we don't want to make a line for every family, it is here because not only is it about their education, it also has the medical component. So when we're talking about major parenting decisions, education, medical, religion, those are always on the list. Here we're hitting two of those.
Yeah, so the critique from the red brief on that point on page 44 is that, I'm quoting this, Jimmy presented no evidence to the district court to create any nexus for this sort of medical adjacent daycare claim. And I didn't see any response to that in your gray brief. Can you respond to that now? Can you point us to someplace in the record where you told Judge Bates, hey, this is different than just ordinary daycare or nanny, because this daycare is special autism adjacent program for these kids, and that's why this needs to be treated differently. Did you make that argument to Judge Bates?
I don't have a record site. I'd be happy to get you one. It was definitely part of the discussion that this therapy was happening at daycare, and the parents were involved in that therapy. They were supposed to be doing the training, but the key to that therapy, and this is definitely in the record, and I can get you a record site for it. The key to that is that it's supposed to be about how the parents interact with the child, not necessarily for the daycare to interact with the child, but it was very well known that the therapy was happening at daycare rather than with the parents.
When you read Judge Bates's findings on this, he doesn't mention, he just treats this as daycare. It's just, somebody's going to watch the children rather than educate the children. He doesn't seem to treat this as an educational type program that the kids are in. He just doesn't talk about it. And so that's why I wonder if that was even brought to him or not.
I'm confident that the answer is yes.
Can I ask you one more question about getting back to the sort of slippery slope? We're appellate judges. We review we give a lot of deference and a lot of discretion to the trial judges who see the parties, who hear the testimony, who probably understand a little bit better about the dynamics of these families that come before them. Who are we to say to Judge Bates, no, you know more about Brandy and James than we do. You were wrong in the way that you construed the issue before you. Are you saying that Judge Bates made a legal error? I mean, you are saying that
Yes.
Judge Bates made a legal error. It just seems like if we're drawing lines, if we on this court are drawing lines about what is legal and what is not, major legal decision and what is not, I wonder where the discretion of the trial court comes into that.
Well, so I do think there are gradations in that, like, are we doing daycare or are we doing parental care? And like I said, we've already got the code telling us which one the code prefers, right? So are we doing daycare or are we doing parental care? Now, inside of that, are we doing daycare A or daycare B? That may be a day-to-day decision that the trial court is like, you guys decide, you guys work it out. But we are, as appellate judges, you're responsible for saying, well, how does the law work? What is the law asking in a major parenting decision versus a day-to-day decision? Now, even if it's not a legal error, we would argue that it's an abuse of discretion here for all of the reasons that we've said in our brief.
All right, we'll hear
Thank
from
you.
Appley.
May it please the court, counsel, Jake Hinkins here on behalf of the appellee. Let's dive in where she left off. The appellant here is asking the court to make a major departure from what is the consistent law for legal custody. Legal custody concerns medical, education, religion. And the reason that it concerns those three things is because those three areas transcend either party's time. It doesn't make a difference whose party's time it is because it affects the entire framework of both parties, no matter what. In this situation, Judge Harris, you're exactly right. This is a day-to-day decision-making issue. This really goes to a right of first refusal type of issue where who has the party at that time and what are they doing with them? James didn't consult with Brandy about having his mom watch the kids. that was fine, because that was during his parent time, and he has the right during his parent time to have other people watch the kids. That was not an issue from our
Unless the
perspective.
decree says there's a right of first refusal during the day.
That's absolutely right, and it doesn't. And Judge Bates was very clear as to why it shouldn't do that, because he found that it was unworkable. In paragraph 26 of the original findings, he specifically said that would be unproductive to have anything other than an overnight right of first refusal. There had been so many issues that Judge Bates saw with the pickups and drop-offs where Jimmy wouldn't come or would come late, and it would cause Brandy then, which is then noted in the findings in this case, paragraphs 50 through 52, where he specifically finds this wouldn't work because of Jimmy's slowness and failures to communicate. It made the court averse to changing the right of first refusal. This wasn't something the court didn't think about. This wasn't something that the court didn't go through and analyze. He did. He went through and found the fact that it would make it very difficult for Brandy, this is paragraph 51, to arrange daycare if Jimmy had the right of first refusal and could take the kids anytime he pleases.
So if this is a day-to-day issue that Brandy gets to decide without consulting Jimmy, why should Jimmy have to pay half of these daycare costs?
Because that was ordered in the decree. If they want to address that, they could do that. Jimmy would
Well,
also have
they
that
are
same.
they are addressing it here. That's one of the issues we've got to deal with, isn't it?
I don't believe that it goes hand in hand with this. If the court finds that the right of first refusal was appropriate and left in place, then the fact that he's paying for half under the statute and under the decree, that finding was never challenged, ever, about him paying half in the original decree. That sits. So the fact that he's paying half, the same would be true for Brandy. If Jimmy were utilizing a different daycare provider where he was having to pay for that, Brandy would be required to pay for that. There's no question about that.
Well,
But
I mean, I'm looking at their brief, page 35, 36, and they have a whole page and a half on paying for daycare.
Sure.
At a minimum, if it's truly a physical custody decision, then it should be Brandy's burden to pay for it. That issue's in front of us. I guess I don't understand you telling us that we shouldn't reach that issue.
So what I'm saying to you, Your Honor, is that in the original decree, that was the finding, was that both parties would pay half of the necessary daycare that was utilized during work time. That was not challenged. That finding was not challenged at that time. I don't disagree that they're now coming in and saying, hey, we shouldn't have to have daycare at all because we think that's a legal custody issue. And so if we didn't have daycare, then we wouldn't have the obligation to pay for that daycare. We just think that's wrong. I mean, legally,
Well,
I
here
don't
I
think
see,
that's
I
correct.
see the distinction in terms of who pays for it. I definitely see the distinction Ms. Nelson's raising. Like if the decision is to send the children to, say, a Catholic school that costs money or to a public school that doesn't, that seems like an educational writ large decision, as you say, that transcends whoever's parent time is happening that day. And the parties, if they're sharing legal custody, need to come together and talk about that and try to reach agreement on that. And then if the decision ultimately is, well, we're going to send them to a school that costs money, then the parties should bear that cost 50-50. But if we're talking about a granular day-to-day decision, today I wake up this morning, the kids are in my care, you know what? I'm going to put them in, I'm going to hire a babysitter today. Like, you generally don't ask the other person to pay half of the babysitter costs on a day-to-day, right?
No, so it's not the babysitter issue. That's not the issue. And so I think this goes to the fact that we give these courts significant deference. And the reason that Judge Bates, I believe, found the way that he did and found that this shouldn't be switched is the fact that Brandy had to go get a job because she was receiving no financial support from Jimmy. So, and this is in the findings where it was anticipated that Brandy would be home with the kids actually more. When she was getting no financial assistance, she had to go and get a job. And as a result of that, Judge Bates, I'm sure, determined that that would be equitable. Then if she's going and having to get a job, she's paying for the daycare, Jimmy should be paying for half of that. That is, same thing is true for him. He could go and do that. The fact that he's not, that's fine. But if he were to do that, Brandy would have an obligation to pay him for half of that daycare, because that is the law, that they both pay for half of their required daycare while they're both working. I want to focus.
At least the order of the court. That hasn't
I'm sorry,
been
the law of
amended
the
or
case
changed,
is
yeah.
a better way to say that. Thank you, Your Honor. I want to jump to the overarching issue here and talking about the original decree, the fact that Jimmy was awarded 35.1 in the findings in paragraph 13 in the original findings. the court found that, quote, "this is a high conflict divorce with poor co-parenting abilities." And then Judge Bates, and this is really important, goes through all of the statutory factors. And as the court noted in Tillman, not just the 3-3-10, which is now 81-9-204, and also the 30-3-10.2, which is now the 81-9-205, he went through all of those factors, A to N, with multiple different subparagraphs. The reason that that's important, and this is noted on page 5 of the reply brief, but in the findings in this situation, Judge Bates specifically incorporated those findings into this case in finding that a number of those issues hadn't changed. Ms. Nelson has done a good job of trying to focus the court on two issues, on the idea of this communication and the idea of the travel. However, those were not the primary issues that determined that Brandy had primary physical custody and that Jimmy had 35.1 parent time. The issues, and if the court looks through this is in the record on 2504 through 2514, but specifically talking subparagraph D, and this is paragraph 24 of the original findings and the findings and conclusions of law, where it talked about, quote, "with respect to physical, psychological, and emotional needs of the children, the court finds that this factor weighs heavily in favor of Brandy." Paragraph E, "the ability to give first priority to children's welfare and to reach shared decisions slightly favored Brandy." That was paragraph E. Paragraph F then deals with the distance. Obviously, that weighed against Jimmy at the time. Although he was planning on moving, he had not moved, and there was a significant distance there. And then in paragraph L, again, the court talks about the status quo, which the children were thriving under, which favored Brandy. The reason that that's important, and the reason that the court's analyzing that again here, is the fact that these children are thriving. That was what the court said was their number one issue. And the court is under 30-3-10.4, which is now 81-9-208. It will be nice in a few years when we only have to quote
We only
one of
have
these
to.
sections, right? But it specifically says that the court shall give substantial weight to the existing joint legal custody or joint physical custody order when the child is thriving, happy, and well-adjusted. And that's exactly what the court did here. The findings go through that. Paragraphs 34, paragraph 44, paragraph 45, paragraph 50, paragraph 53. All of those note the fact that these children are thriving under the current situation. So not only did the court go through and analyze all of the -10, but also the -10.2 factors and determined ultimately that these children were thriving. There was no reason to upset the apple cart. In fact, the quote from the court was, "If it ain't broke, don't fix it." And that's exactly what the court did here. Ms. Nelson talks a lot about the fact that these guys are talking, the court is dealing with communication issues and saying that that's not part of this analysis. That's not true. It is a part of the analysis, and it's specifically captured in 30-3-10.2 2C, which is now 81-9-205 5C, which specifically talks about co-parenting skills and addresses, quote, "the ability to appropriately communicate with the other parent as being one of those skills that is necessary for these parties to be able to communicate and co-parent together." The court had found, again, you have a question?
I was just gonna ask, and this is probably playing devil's advocate a little
Sure.
bit because of my prior questions, but doesn't a focus on communication between the parents shift the trial court's sort of decision that parental communication is very important in this situation? Doesn't that shift the focus from what is in the best interest of the children to the focus on the interpersonal relationship between the parents?
It doesn't. And the reason why it doesn't is because that factor is one of the required factors that the court shall address under the best interest analysis. So as part of best interest, we want parents to communicate well together. Talking about the 35.2 factors, that is a very broad overarching thing, but ultimately, as that initial point in the 35.2 factors, there has to be a best interest analysis. You have to find that in order for these folks to be able to co-parent well together, well, in order to have a 50-50 relationship, they have to co-parent well together. If they don't, it doesn't work. And that's one of the factors specifically that the court has to analyze is there an ability to appropriately communicate with the other parent? The court found that right now, there isn't. Has it gotten better? Sure. But it's not where it ought to be. And the court, that's not the primary focus of the court. Again, as I noted, 5 different times in the court's specific findings, he goes through the fact that these children are thriving. That is the primary reason that he focuses on, which was the 10.4 factor required by the law to be given substantial weight. And he gave it that substantial weight. And that's the reason that he didn't shift anything with custody. I want to address the mootness issue. I don't think that there is a mootness issue. I think that, I'm certainly not going to say how they argue their issues, but the fact that Jimmy was found in contempt was appropriate. The court went through, the court found that he was voluntarily unemployed. The court found that.
Well, if they're withdrawing their challenge to the court's decisions on that point, are you really going to look that gift horse in the mouth?
No, I'm not. That's what I
Do you want
said.
us to do something else with that?
I just don't want Ms. Nelson to stand up in rebuttal and then make an argument that I haven't addressed. And so that's all I'm saying is if they are withdrawing that challenge, no problem. But if they're not.
That's how I understood the suggestion of mootness to
Okay.
read. I have a copy of it right here. Issue 3 of the brief is moot. Issue 3 included everything having to do with contempt. So I read it, at least having to do with Jimmy being held in contempt. Their argument about the court
Yeah.
erred by not holding Brandy in contempt was in issue 2. So I understood this mootness, Ms. Nelson can clarify when she stands back up, but
Okay.
I understood it to get rid of everything in issue 3.
As long as that's the case, then I won't address it any further. But we believe that was all appropriate. We don't think the issue is moot. We don't think that some of the evidence that's been suggested suggests what she's saying. That's it. So if I don't need to address it, that's fine. I will go back then and only address the issue with Brandy and her contempt. And I think, Your Honor, that what you've stated is exactly correct. How could Brandy know what was required in an order that the judge himself who gave the order specifically found that was not what it meant? I don't think she could ever be held in contempt for that. If the judge himself says it meant something different than what they're now suggesting, how could Brandy somehow divine that would be the case? When she's reading it the same way that the judge is reading it and just following it, then I don't think that she can be held in contempt.
Can I ask you about this education component to the daycare
Yes.
that they're raising?
Yeah.
And get you to comment on what
Yep.
you said in your brief, that, hey, this wasn't really put in front of Judge Bates below. Ms. Nelson says, well, yes, it was. I can get you a record site. What's your response?
It wasn't, and the reason that it wasn't is because daycare didn't provide ABA therapy. Here's what happened. The ABA therapists would come either to the homes or they would come to daycare. But whether they were at daycare or whether they were in the home, whether they were somewhere else, that's who was providing the ABA therapy. It wasn't the daycare providing ABA therapy. And so.
In other words, there was nothing presented to the court indicating that this particular daycare was a special daycare that provided additional services that you couldn't get at another daycare.
Yeah, that's correct. This was a very good daycare. Brandy had spent a significant amount of time to find this daycare specifically because it was a good daycare. But was it somehow providing additional medical services or educational services? No, it was doing the same thing that other daycares in the valley there in Utah Valley were doing, but they would allow the ABA therapists to come there and to work with the children. Some of these issues are somewhat moot at this point. These children are both in school now at this point. The daycare is a very minimal component of any of this, which happens as a product of a case
The
that's been
youngest
going
child
for
is
5
how old
years.
now?
He's 7. 7.
Okay.
So my time is up. So if there are no more questions, I will rest and
I don't
request
see
that the
any
court,
others.
affirm. Thank you.
Thank you. I'm going to start with Mr. Hinken's last point about the children having aged out. True, but they still have after-school nanny care on mom's days. which is Monday, Wednesday, and every other Friday. And during the summertime, on mom's days, they are going to daycare or, I was gonna say camp, but I think it's at the daycare, or it's at a daycare. So it's not, that was one of my first questions. How old are these kids now? Is this still a problem? The answer was yes, this is still a problem. We've still got aftercare and summertime care.
How about, do you take any issue with their description of how therapy was being applied?
I think that may be accurate. What is certainly true is that the ABA therapy was happening at the daycare, and that the daycare was facilitating that. I don't take any issue with the way that they actually described that. One thing that really stands out to me in Mr. Hinkin's description of all of the best interest factors is that I understand the findings originally made that, but then in the petition to modify, communication is such an important part of it. The communication seems to rise above all of those other factors. And we see in paragraph 48 where
Well,
the court says,
Well, let me tell you how I read it, and then you tell me why I'm wrong. The court was in, I think it's 40-something, was it 43? Yeah, 43, that said the court determines that all other findings made by the court in support of its initial custody and parent time decision remain the same. So it's saying that I've now compared the evidence I've heard on the petition to modify with the evidence I heard before, and I don't really find that there's any material difference, and so my findings are gonna remain the same. So when the court focuses on communication to the extent it does, one of the reasons that we have the petition modify is the allegation is that communication's getting better. And to me, it seems like the court's saying, yeah, true, it is getting better, but it isn't where it needs to be. And so that the focus is on that, not because he's putting undue weight on it, but he's simply isolating something different than the findings he made previously. Why is that wrong?
well, he's still, I would turn you to paragraph 48. The court is also concerned about the parties' ability to co-parent on a 50-50 schedule. 50-50 is for parents who co-parent well. It requires mutual respect, flexibility, and frequent communication, and the parties do not yet have that. I actually don't think that that's correct. I mean, we have a statute on equal parent time, 819305, and those three factors are the equal parent time schedule is in the minor child's best interest. Each parent has been actively involved in the minor child's life, and each parent can effectively facilitate the equal parent time schedule. And to the extent that he's concerned about frequent communication, which seems to be the problem, he's not talking about the hostile communications anymore, he's talking about frequency of communication. He puts in an order to make sure that Jimmy and Brandy respond to each other within 24 hours. So there's another way of solving that problem. There's still not a question about what is in the kid's best interest. And I am glad that those kids are thriving. That is great, but would they be doing even better if they were spending more time with dad? So then we go to we go to paragraph 70 again, which seems like it's telling us where we're going, but it's so unclear. It says, I read it earlier, the parties should be more flexible and try to do what's in the best interest of the kids. If we come back in a few years and I find that the parties are working really well together and the kids are a little older, 50-50 is always great for kids. But I need to see the parties communicating better. That does sound like he's making communication the main thing. If we come back later and you're communicating better, then 50-50 is always great for kids. That's what he says. So, but all of the other factors that Mr. Hinkins talked about are presumably still going to be the case in the future. Hopefully the kids are still thriving in the future. So is this paragraph 70 saying, yes, Jimmy, someday you may get 50-50 if there's better communication? Or is this just, no, this is not going to happen. We want you to improve communication for the sake of improving communication, but we're never actually going to change it. Those kids are never actually going to get 50-50 time with their dad. You're never actually going to get 50-50 time with your kids. Sorry, end of discussion. That's the rock and hard place that my client is put in. Like, I'm trying hard to improve my communications. My primary concern is about spending time with my kids. I want to be with my kids. There's actually no reason that I can't be with my kids other than that you don't think that I'm communicating very well with mom. I'm trying. So this is the problem that we see, and that's why we've brought this to the court, saying that the trial court's abused its discretion here in setting up all these barriers to having 50-50 without actually an analysis of whether that's in the children's best interest.
Can
So
I-
does-
can
would
I-
that-
Oh, go
I
ahead.
was just gonna ask quickly, does that require, are you asking us to reverse and remand for
Oh, I am so glad you
different-
asked that.
different? I mean, if the court put in place different findings or a different order, a more specific order, and we're still, could we still be in the same place?
I appreciate you asking that because I forgot. This court has previously instructed a trial court to go back and change it to 50-50. That was in Nakina versus Mahanthi, and that is what we would ask for. I mean, I guess the next step would be reverse and remand, but we would actually ask this court to do what it did in Nakina and go ahead and enter 50-50.
Can I ask about the childcare expenses? So the response I got from Mr. Hinkins when I asked him about this was, hey, we've got a provision in the original decree, and I just found it. It's paragraph 32 of the original decree that says the parties shall follow Utah Code annotated 78B 12214 and share equally the reasonable work-related childcare expenses for the minor children. He says, look, that's law of the case. He doesn't think that your petition to modify below actually asked that that be changed. And so the discussion he says the parties were having about daycare was really about whose decision it was, not necessarily about who's going to pay for it. I think that's what he said, and I'd like your response to that argument.
Okay. My response to that argument is that as you pointed out, we certainly have brought it front and center as part of our appeal. And part of saying this is actually a legal custody decision. This isn't a day-to-day thing. You're asking me to pay money for things. That supports that theory. Of course, we didn't appeal that component of the decree. We're not here appealing the decree. Your specific question that I have to confess I don't know the answer to, and I don't want to give you a wrong answer, is
Well,
whether it
you're-
was part of the petition to modify.
You're here appealing the court's decision on the petition to modify, and if you didn't ask the court to modify that provision, then I'm not sure we can really help you here. That's a preservation problem, not a waiver problem. So you can put it in your brief all you want, but if you didn't ask the district court to modify that provision, I'm not sure we can help you here, and I don't know the answer to that.
And I don't know the answer to it either and don't want to give you a wrong answer.
All right, fair enough.
Easy enough to find out.
I
though.
appreciate the candor, but we will take a look, and I'm sure you will too, and if you find anything useful, there, you know how to get a hold of us.
I do know how to get a hold of you, yes.
24
Thank you,
Jan. So,
thank you.
okay, thank you.
Do I need to say anything on the mootness issue?
No.
So are
unless-
you waiving, are you,
Unless you think I've mischaracterized the scope of your suggestion.
No, we think issue 3 is
With-
moot because the contempt is purged. Therefore, it's moot. This doesn't matter anymore.
attorney's
Well-
fees, or what about the attorney's fees?
The order, there's a new order replacing the old order.
Okay.
And the new order says that she can garnish it. So problem solved. And he's not in contempt of that.
Okay.
Thank you.
I don't know everybody in the room, lest anybody misunderstand what was just said. When Judge Harris says, you know how to get a hold of us, what he meant was you could
You
send
can
us a
file
Thank
a
you.
letter.
formal letter under the rules, and we'll read your
Rule
letter.
24 of the Utah Rules of Appellate Procedure, you said, sets forth the basis for
you
how
call
you
us on the
get a hold of
I
us.
believe
We
it's
are not
section J.
answering. All right, great.
Got it.
All right. This is now adjourned.
I like that. You went together.